What's up, everybody? We're on for our second live of the day to break down these Brian Kohberger hearings. We talked about the arraignment at length already in an earlier video. If you want to check that out, we dive deep on standing silent, on agreeing that he understands the rights, agreeing that his name is there, and all the questions that surround the arraignment. And to be clear, standing silent, I just posted a short on it, on what it could be and all the possibilities. It is not unheard of. It is not a once in 1,000 cases. Lots of criminal defendants do this, and there are lots of different reasons. And we've done this in our cases for different reasons. And usually you make, when I say the decision was intentional, I don't mean I know what Brian Kohberger is thinking. I mean, they discussed the options and they made the decision to stand silent. So if you want to check out a short video breaking that down and diving a little deeper into that, it's on Instagram and Twitter now. The longer video is, of course, on YouTube. But in this video, we are going to focus on the scheduling conferences, motion hearings. They've been called motion hearings, but we didn't actually have the arguments on the motions. It was more to schedule them. So we're going to talk about how scheduling is going to work in this case, keeping in mind that the trial is set right now for October 2nd, which is near the end of the speedy trial period, not quite at the end. There's about 6 weeks additional that if there is some kind of continuance, they have time for a short continuance before they try the case. But knowing that this is almost a one-off, that they have to continue to litigate these issues because of the high-profile nature of this case, that is going to dig into some of the time they would have had preparing their actual defense and prosecution. So I think the timing of these gag orders is important in addition to the timing of the motions to compel. And as we hear, the motions to compel are going to come after the gag order. They're going to deal with this gag order first. And there may be differing arguments between the media and the Gonsalves family, or the victims' arguments, as to how to deal with the gag order. And I think we start to learn where this judge is leaning. And I have a guess as to what the judge's decision is going to be at the end of the day when we finally have these hearings in a couple weeks. So hit that like button if you guys are enjoying the video, and make sure you subscribe to our page if you haven't already, and hit that alarm bell because you never know when we're going to do a live. But we're back at our 8:45 time tonight. We've hung out during a lot of trials doing recaps in this time slot. So feels good to be back hanging with you all again tonight. And of course, I will answer your questions along the way. I'm going to pause the hearing to make some comments and to answer your questions. Put some new members up on the screen. We will enjoy our time. Whoops. I lost it. Here we go. All right. So here we go. We are going to watch this hearing together.
Okay, we are back. Almost. Thank you. We are back on the record. State of Idaho versus Brian C. Kohberger, CR 2922-2805. Mr. Kohberger is still back in the courtroom. Ms. Taylor is representing him, also with Mr. Logston, excuse me. And I have Mr. Thompson, Lake County Prosecuting Attorney, representing the state, and with him is Brad Rudley, also the Lake County Prosecutor's Office. So, I'm sorry? Yes, Mr. Gray. Okay, thank you, Mr. Gray. I was going to get to that because I was going to go in a list with the media, Associated Press et al. Is Ms. Olson here? Is she on Zoom? No, maybe not. Is there a lawyer representing Associated Press at all?
Well, there is.
There's a gentleman trying to talk to you, but he's muted.
Oh, Mr. Carone, you are muted. Well, now I can't hear you. Maybe it's my problem. Barely. Yeah.
The screen is muted.
Okay. Yeah, let's open it up. Okay. Say something.
So just in case you haven't noticed, I haven't watched this in its entirety. just clips of it. So we're going to break it down and watch it for the first time together. Sounds like they have some technical difficulties right off the jump, which we understand here on this channel.
Still, I don't know. Technology's great until it's not. Are your speakers all the way out, Mr. Carone?
Skipping ahead a little bit.
We have tech people.
We have tech people.
Somebody is trying to now say something. Oh yeah, I just moved my things. Okay. Really sorry for all the delays. I recognize Mr. Gray, who's representing the Gonsalves family. My plan was to go through the variety of motions that each representative has, starting with the Associated Press, then going to the Gonsalves family, and then to the party's council, and we'll see where we go. But we're not going to have an 11 o'clock because we're just going to take care of all the scheduling issues now in this hearing.
Thank you, Your Honor.
Thank you. Yeah, let's go off the record until we can fix this. Thank you.
I can hear you, Mr. Barone.
All right. Seems like we've figured it out. It has to start, Nikki. It has to start.
Okay, is that better? Oh, brilliant. Thank you very much. Okay, thank you, Jennifer. Let's get back on the record then. Back on the record, State versus Brian Kohberger, CR 29222805. I was explaining how the order and the scheduling conference might go, at least my plan. And so I'm going to start with you, Mr. Carone. Your clients have the motion to vacate the amended non-dissemination order filed May 1. Also, the motion to intervene filed May 1, same date. And now this case is in my hands, so I need to set a hearing. And I'm wondering how far out. I'd like to get some briefs, and this is a message to everybody before the hearing, including I want to hear arguments about whether or not there should be cameras in the courtroom in a high-profile case like this one. So, Mr. Carone, what?
So that at the very least, just right there, right? Because he's going to start to tip his hand a little bit and show us his hand, I guess is what I mean by that. He says, I need arguments why we even need cameras in the courtroom of such a high-profile case. So you're going to track here and understand where he's going with this and how it's going to be an uphill battle for the media.
What looks good for you? And let me throw out, knowing that a lot of you were prepared to be here the week of June 26th, that might make sense. But I'll hear from you, Mr. Carone.
Yes, Your Honor. So with our motion to vacate, motion to intervene, we briefed the merits issues there. I think as the court's aware, we also briefed those issues for the Idaho Supreme Court. So I would think we could be ready to move pretty quickly. We have not briefed the issue about video cameras in the courtroom. So if that's something that you'd like the media coalition to weigh in on as well, we would need to submit a separate brief on that, but we can do that in the week of the 26th. The 26th itself, I'm not available, but the rest of the week would work.
Excellent. And I'll tell you, the reason that I'm bringing up cameras in the courtroom is because if I address that issue, and I haven't let you all know that that might be an issue, then I'm going to get a lot of grief for not allowing you to brief that issue. So that's why I'm giving you an advance notice on that.
He's basically saying, we know we're arguing about a gag order. We're arguing about what we can talk about in this case, but you should also start briefing why I should even allow cameras in the courtroom. Again, same state as Lori Vallow, where they ended up not allowing them at the end of the day. So he needs to hear why they need to be in here. So the media has to tell him why.
How do you feel about the afternoon of June 27? Given what's happening just quite recently, we might want to do that in person. I'm willing to do it remotely, but then we have to. There are a lot of different interests and different people who want to weigh in on that, so it might be better to do it in person. But, does that work for you? Say starting at 1:30, June 27, Mr. Corona?
Yes, Your Honor, that works for me. And Ms. Olson and myself can both come in person. We would have been there today in person, but we found out about the in-person option on Friday, so I apologize for using Zoom today, but we can certainly be there in person. If the court's anticipating hearing from witnesses that day and hold an evidentiary hearing, there may be some witnesses that would want to appear via Zoom if that's okay with the court. I'm not sure if that's even something you're contemplating. I'm just flagging it in case you are.
Well, let me put it this way: it's your motion and others' motions. One of the complaints that I've seen in the briefing is that there's no evidence in the case supporting any of it. You know, we're all kind of moving forward on supposition, I guess. And some of it is obvious, but I think that would be wise. I suppose you could just file declarations, and that's what's been doing, how that's been going. If we're going to have a lot of testimony, I might want to move this back to 10 a.m. just to make sure that you have enough time to get things finished that day.
So some of the questions that are coming in that are relevant to where we're at. Tammy asked, what are the cons for cameras in the courtroom? In the Lori Vallow case, they talked about how people were going to talk more about her appearance and, you know, what the looks on her face. People are talking about Kohberger smiling or giggling or whatever it is. And that stuff gets taken and it just gets, you know, Bill Simmons says aggregators. So the aggregators get it on the internet and they start writing articles about Kohberger laughing in court. He doesn't care, whatever. And we don't want that stuff to spin out of control. So there are some cons. Is it necessary to actually see what they look like, or do you just need to hear it? So there will be arguments made, and what the case law says. And again, we already see some precedent for this in Idaho where it might not happen. Chief asked, do you think the case will actually get to trial in 2023? I think there's a less than 10% chance, but I do think there is a chance. In a lot of cases, I say 0%, but because of the kind of the context and what's going on in this case, I think there is a chance, although it's a slim chance. Jen, how did they handle things like this before Zoom? So a lot of times it was just handled by phone, which a lot of judges would not even allow you to do this telephonically. If it was a deposition or a witness statement, sometimes you'd have to tape it beforehand like a video depo, and we couldn't do a live Zoom depo. And there was some video conferencing that we could do through the court system that was miserably hard and nowhere near as easy as Zoom. So you can imagine how difficult it was compared to this. Tiffany, I did a short video on this, about 2 minutes long, on Twitter and Instagram. Tragos Law is my handle on there if you want to check it out for an answer on this one. And Tom, sounds like a full day for you as well. And yet you're here hanging out. We're all hanging out together, talking through this stuff, hopefully learning something.
Would that work for you?
Yeah, so our position on the evidentiary issue is your summary was correct, that we don't believe that there is an adequate factual record at this point. Given that it is our motion and it's based on the record that existed when the order was issued, procedurally, I'm not really sure there is an opportunity for additional evidence to be put forth. I only brought that up because I saw in Mr. Kohberger's opposition to our motion for reconsideration that there was a mention of an expert witness. If that evidence was going to come forward or other evidence, we of course would want the opportunity to cross-examine that individual or whatever individuals might be testifying. But as things currently stand for the record as it exists and the evidence that the media coalition intends to put forward, we included a declaration with their motion. I'm not sure there's really need for us to put on additional evidence, but if that's something the court was going to hear from the state of Mr. Kohberger, then I just wanted to bring that to the court's attention.
Thank you, Mr. Corona. Of course, you'd have the opportunity to cross-examine anyways. All right. Well, we'll stay at 1:30 then. So now, Mr. Gray. So I'm thinking that maybe we should keep these things together and do them the same day if that works for you and the clients.
Well, Your Honor, I see the issue very clearly different from the AP's motion versus my motion.
Gray is like, he represents the Gonzalez family. He's like, no, Judge, I'm not with them. Ours is different. We don't necessarily want this thing to just be open. My guess is he's going to say, I just want to speak on behalf of the family. But I did hear that he tried to differentiate from the media.
I think their motion is more of a getting rid of the non-dissemination order, the gag order. My motion is a motion to amend and or clarify some of the issues in the gag order. They have a lot of constitutional different issues that we have. I have some issues that I think are very separate. So I would request a hearing on my own much sooner. I think the court's aware I filed this motion in February on this case, and there was a massive delay based on the fact that the previous judge, Judge Marshall, was waiting for the Supreme Court to get some clarification regarding the AP's motion that she filed with the Supreme Court. So I'm ready to go when the court's ready to go, but I think our issues are very, very different than that of the AP's motion on this case. So I would request a hearing much sooner than I can do it by the end of this week.
All right. Well, and I recognize this was all pretty short notice for everybody. And I don't know if, let me go back. Let me go to Mr. Rudley and then Mr. Logsdon, because they're going to weigh in on that motion as well, I'm assuming. I'm thinking about maybe June 9th would be the soonest I could do this. But
That's when they end up scheduling it for.
Yeah, we'd be ready to go and would expect to put on an evidentiary presentation that week of the 26th. To the extent that Mr. Gray wants to have his motion heard ahead of time, and just based on what I've read in it. I mean, obviously, if the court would agree with some of the things that he says.
into the mic, I guess.
Sorry. Obviously, if the court would agree with some of the things that he says and wants amending the order, that could change everything for everybody else. So to some extent, I think it actually probably better do them all at the same time, so the court isn't in piecemeal changing what we're all arguing about. But I would be ready for the 9th if the court chose to do it that way.
No judge likes to do things piecemeal. But I also understand that.
Honestly, it only makes sense to do all this together, even though there are some differences. And it seems like people, even the defense and the prosecution, might agree with some of Shannon Gray's amendments, but not what the AP wants. But it just makes sense to handle all these together, which is what they end up doing.
Mr. Gray and his clients have been waiting for a long time now. It's not anybody's fault. It's just how that came down, because the Associated Press et al. Went straight to the Supreme Court in February, early February, and that would trigger a delay, which it did, and it was important, I think, for Judge Marshall to get the direction from the Idaho Supreme Court before we start, chipping away at each order. I don't know if would you be. I mean, I'm okay setting it for June 9th, Mr. Gray, but you may have some testimony happening. You may want to wait until you hear what everybody else is saying. It's likely that there's going to be some adjustments, you might say, or clarifying in the order. Partly in my reading of the Supreme Court's decision. Maybe I'm reading too much into it, but there were some hints maybe of what the trial court might want to consider. Okay, go ahead, Mr. Gray.
I was going to say, since this is your gag order now, it's non-dissemination order, Your Honor. And in reading my motion, if the court does want to consider making some of the modifications that might have been suggested in my motion, my motion may end up being moot. I think some of my modifications and or clarifications to the non-dissemination order are fairly minor, but allows, and I think the Supreme Court did give some guidance, which I think added weight to my arguments in my motion. So it's not above the court to take a look at my motion as well as any other motions that have been submitted to the court and modify the non-dissemination order, allowing for some of the issues that I discussed in my motion. And then you would only have the AP who are attacking, I think, the gag order as a whole, the non-dissemination order as a whole. I'm just addressing a couple of clarifications and amendments that would allow myself as an attorney to speak on behalf of my clients regarding the non-dissemination order. And I think it's your order now, so you're more than apt to be able to go and make those changes, and then we wouldn't have an issue with the non-dissemination order at all. So I don't think so. Obviously, the 9th, I'd like to keep the 9th because my issues are very small and narrow regarding that non-dissemination order. But if you were to make changes to those ahead of time that I was able to review and it was acceptable, I would withdraw my motion, Your Honor.
Thank you, Mr. Gray.
Thank you.
Well, I'm
Trying to make things quicker. That's what he's doing. He's trying to move it along. If you can just give me some amendments, I can withdraw my motion. You can just handle the AP. Thank a farmer. Could the government offset the cost by bringing in court TV? The cost is not the issue. Tons of media organizations would pay for all of this stuff. It's more the defendant's right to a fair trial and the ability to find a jury pool that has not been poisoned by the live streaming and the media coverage and things like that. Brooke, hi, Peter. What's your first impression of Judge Judge? I think that he tells you kind of how he feels. He tips his hand and kind of shows you what he's thinking and where he's going to rule. We haven't seen all of that yet because we're going to see it when he talks to the media a little bit more. I think he wears his emotions on his sleeve a little more than your average judge, maybe. And when he gets mad, I think we're going to be able to tell when he gets mad, when he gets annoyed, or when he agrees with somebody. I think he's going to show it a little more than we've had some stoic judges lately. I could be wrong, though. That's just a first impression. This may have been answered already, but wondering where the motion to compel stands. Has evidence been turned over yet? Thank you. No. They are going to have that hearing on June 27th. We haven't gotten there yet. That's at the end of the video. We may not even watch it because basically they just agree June 27th. They're going to handle that motion to compel. So if you guys are kind of getting bored with the video, we don't have to finish it, but I really want to talk through what he says to the media because that gives us an idea as to where this judge stands on the gag order.
It'd be highly unlikely for me to change the order before I hear from counsel. Because I don't want to.
So he said he doesn't want to change the order until he hears all the arguments, which makes sense.
Third, fourth, fifth, sixth. I know we want to do this once. And I'm happy to set it for June 9th, maybe 10:30. Does that work for you?
That does, Your Honor.
Okay. Does that work for you, Mr. Rudley?
Yes, Your Honor, it does.
Okay. Mr. Logston?
Make it work, Judge.
Okay. Let's do that in person. Okay. So now we have the June 9th at 10:30. We also have the Associated Press et al. On June 27th at 1:30. I assume that works for you, Mr. Rudley?
It does, Your Honor.
Okay.
Yes, sir.
Okay, excellent.
Your Honor, may I speak?
Yes, Mr. Corona.
Your Honor, I apologize. I may have misunderstood what you said earlier. I was understanding that the week of June 26th was when the court was first available, but if the court is available to hear our motion earlier, we would be available on June 9th as well. I know that our most recent motion is pending more recently, but obviously.
He said, we want to get this done. The Associated Press is pushing because there's irreparable harm. More on that later. But he said, I thought that was the first available date, so I want to get ours done June 9th too. Can we get it done June 9th? And Jesse Sue, thank you. I've been drinking them still.
Challenging this since February 12th. It's our position that the non-dissemination order violates the Associated Press and Media Coalition's First Amendment rights. Those constitutional violations are irreparable. So we would like our motions to be heard as soon as possible as well. If I suggested otherwise, I agree with the 26th. That was simply because I misunderstood that was when the court was first available.
He drops the First Amendment and irreparable harm again, and we're going to hear that from the judge.
Thank you. Oh, only one thing I'll say about that. Irreparable harm goes both ways.
Here we go. The judge just couldn't help himself. He feels obligated to say something. He's like, listen, irreparable harm goes both ways. And this is the beginning here. So if you've dozed off, not paying attention, focus up. Because all the questions about the gag order, where it's going, what the judge is going to say, he is about to give it to the AP a little bit here and tell him what he thinks about their motions, about how they sent it up to the Supreme Court, delaying Shannon Gray's motion, the ability to have this heard and decided on. But he's going to tell him at this point how he feels about some of their arguments and how he balances all of the rights that are in the courtroom.
And so I was a little bit troubled by that claim without considering the Sixth Amendment considerations. I mean, this is a balancing. The law is clear on this. Okay, it's a balancing test. And when your client says that he's arguing it as the First Amendment is absolute, is also troubling. So I would suggest that maybe the Associated Press needs to tone it down, just ratchet down a little bit. Because
so anytime a judge tells you that your argument is troubling and you need to tone it down and ratchet down a little bit, it's not a great thing. Now, you're zealously representing your clients, fighting for the rights you think are important, especially public rights. Lawyers have to be reprimanded sometimes and dressed down, as people say, from the court, and they're right sometimes. I mean, that's how a lot of things are changed, right? As we push boundaries and we fight for what's right. We fight for justice. We fight for our constitutional rights, the First Amendment and the Sixth Amendment. So I'm not saying they're wrong, and I'm not saying every time a judge disagrees with the lawyer's filing, it's happened to me before, but usually it doesn't mean they're going to rule with you. So you've got an uphill battle in front of you, and that's what it feels like here. And I do agree with the judge. It's not just about the First Amendment right. We talked about that on this channel when we have already read through the motions. The Sixth Amendment right is more important, right? Brian Kohberger's fair trial in an unbiased jury is more important than the public's ability to watch it live stream. They're not going to lock the doors. They're not going to kick the public out. Certain parts they may, but that is important, and they don't mention it in their arguments. Somebody said and asked the question here, irreparable harm both ways. Yeah. Irreparable harm that's being done to the media companies and the public, how we're not finding out what's going on in this case. Sure, that's irreparable harm that we can't get back. But the judge said, if we just get rid of the gag order and the media gets a hold of certain things and Brian Kohberger is publicly condemned and the entire jury pool is poisoned, that is the ultimate irreparable harm. You cannot fix that. You can't go back. Now we're changing venue. We're sequestering juries, and we don't want that. So that's how irreparable harm can go both ways. But there's more.
Some of the arguments, including the first line in the motion to intervene, says that the Supreme Court held a certain thing, that I do not think that is what the court held. And you know the difference in a holding of an appellate court. So I just felt obligated to help you out a little bit in terms of what the Associated Press is asking for.
Okay. Again, I've been here in hearings, right, where it's not going well for you. I've been here, so I'm not condemning this lawyer at all. I mean, he's the AP's lawyer. He must be a pretty good lawyer, right? But when a judge tells you that you should know, and you do know what it means for an appellate court to hold something, to have a holding, and to say that the Supreme Court held, you should know what that means. And in your argument, you were wrong. The way that you argued that the Supreme Court held something, that was not a holding. And I feel obligated to help you out with that. That's what the judge said. Obligated to explain to this lawyer what it means for an appellate court or a higher court to have an actual holding in a case. And we talked about it. The Supreme Court basically didn't make a decision. They said it's moot. We can't make this decision because it shouldn't come to us yet. You have to exhaust the speedy remedies that are in front of you with the lower court. So they didn't actually hold anything. And I think that's what the judge means. But again, not great for the AP. John, do you think Judge Elizabeth Scheer wore her feelings on her sleeve? Could this be similar? I mean, I've gotten more hate about discussions about Judge Scheer, who I didn't think was a horrible judge. I think she did a couple things that I didn't agree with that I didn't think a judge should do. That was it. And I read a letter that the FACDL wrote. I think at times she did. I think at times she didn't. I think she was pretty stoic and stern throughout the whole process. I think she got frustrated at times, but I would not say she wore her emotions on her sleeve the entire time. Brooklyn Basement, glad you're here. Joy Puffle was at the dog park wearing my Lawyer You Know shirt. A lady stopped me to talk about it and had a 15-minute conversation about you. Love this channel and thank you for your insight. That's hilarious. It very rarely happens to me. Only maybe like 1 or 2 times has anybody come up to me and talked about it. So if you see me around, come up and let me know if you watch, if you hang out in the chat.
And in the meantime, there's a lot of potential irreparable harm from media that is affecting a fair trial. So that is really concerning.
There is a lot. He doesn't say there may be in the future. There is a lot of irreparable harm coming from the media that is affecting a fair trial. I'm not a rocket scientist here, but I think you're all with me in seeing where Judge is leaning. I think he's leaning in absolutely keeping this gag order in place. I think he may amend it to allow Shannon Gray to speak on behalf of his clients, but he is not getting rid of this gag order. I would be shocked if he got rid of this gag order. And I don't think it's a coincidence that Dateline NBC piece came out this weekend. I'd be willing to bet Judge either saw it or got a synopsis from someone about it. And he was probably none too thrilled. And I bet that made him even more solidified in his position that this gag order is actually preventing irreparable harm, not causing irreparable harm, or at least preventing more irreparable harm than it's creating. That's the lane I feel like he's in. Let me know in the comments if you agree. And John, why don't you throw a poll up? Will the judge withdraw the gag order? Yes or no? And if you think he just is going to amend it for Shannon Gray or do some amendments, then put no, he's not going to withdraw it. And hopefully, I'm sure I just made everybody in the chat sway a certain way, but tell me what you think. That's what this is about. Don't agree with me just to agree with me. Tell me what you think.
This is a very high profile case. So I'm happy to set this on June 9th too. Okay, how about we set yours at 1:30 then? So we don't kind of push them all together. Does that work for you, Mr. Rudley?
It does, Your Honor.
Okay, does that work for you, Mr. Logsdon?
Sure, I don't know if we'll have an evidentiary presentation ready by the 9th. That would be my concern. We can certainly try.
Well, let's see, and if that doesn't work out for you, then we'll talk about it. Okay, I just felt the obligation to talk about irreparable harm. Okay, there's a lot of interest here, Mr. Carone, and I think my job, my constitutional responsibility is to consider all of the potential irreparable harms or all the injuries or all the harms. So, I just want, maybe it's appropriate. I was just thinking, I just want to remind everybody, okay, on this particular issue, but all issues at all times, that we all, okay, judges, lawyers, journalists, media generally, have constitutional responsibilities to both the First Amendment and the Sixth Amendment. And what I generally am seeing in the newspaper and the media is no discussion about the importance of the Sixth Amendment. It's just the First Amendment.
He must not be watching The Lawyer You Know, right? We've been talking about the Sixth Amendment a lot. And I'm just messing around, but he is absolutely right. And I've been saying this forever, and I said it with JB today. And I think JB does a great job at this. If the media would be a little bit more balanced and consider the rights of the criminal defendant and consider that he's presumed innocent and really consider it, not as an afterthought, not saying things like, we know he did it for this reason. He has the profile of a serial killer. He must have done it before. He was following this girl. Oh, but we know he's presumed innocent until proven guilty. It's like, it's not a throwaway. That's a real thing, right? It's like Harry Potter's invisibility cloak. When you're cloaked in the presumption of innocence, you are innocent, just like Harry is invisible. Then you take it off and he's not. And I think that's really, really important for us to remember and discuss. And I wish the media would do more of it because I think that would give them more access, not less. Sandra, holding, creating new law, right? Not always creating new law, but they are making a decision of law, right? So they can just take other precedent, apply it, say, this is how it's always been, so this is why we're deciding it this way. This is what the statute already says. This is our reading, or based on the case law, this is what we're deciding. So it doesn't always have to be new, but it is actually making a decision. Welcome to all the new members. Pumped to have you. It's going to be, I think my favorite members only live is going to be this week, Thursday.
Which is very important. But here's the real reminder. The first sentence of the preamble of the Idaho Rules of Professional Conduct says that a lawyer, as a member of the legal profession, is a representative of clients, an officer of the legal system, and a public citizen having special responsibility for the quality of justice. We all have that responsibility. And sometimes we push in a hard way for our clients, and that's appropriate. But you have larger responsibilities at the same time. Okay, so we got a hearing 10:30. That's for the Gonzalez family with Mr. Gray. 1:30 is the Associated Press et al. With Mr. Carone. And I think that deals with all the pending motions. For you, Mr. Gray, you articulated what your motion is. So we would address that.
Thank you, Your Honor. Yes,
Okay.
yes, Your Honor.
You're welcome. And Mr. Carone, those two issues that are still outliers on your clients, I think that's all we have. The motion to vacate the amended non-dissemination order and the motion to intervene. Anything else that we need to address for your clients, Mr. Carone?
No, Your Honor, unless you mentioned the broadcasting issue as well. I'm not sure if you're going to set a separate briefing schedule for that. Obviously, the motions don't follow the briefing schedule wasn't going to follow that. I just didn't know
Yes.
when exactly we wanted that briefing.
I'm going to send a briefing schedule out for everybody. And now, okay, if we're going to do it on June 9th, you don't have very much time to do those briefs. So that's why I was thinking it made a lot more sense to do it at the end of June.
But no, they do want to push the timeline. And I think that's fair and appropriate to push the timeline. And I think like the initial briefs are due June 2nd, which is, 10 days. And then the reply briefs are due June 8th. And then June 9th, we're having the hearing.
If you all think you're ready to do that, I'm willing to hear it. But I want those briefs. We'll say by June 2nd. Response briefs will be due by June 6th, and any reply briefs due by June 8th. So that's going to be rapid briefing. Just trying to accommodate everybody. Okay? I got a lot of interest floating around on these issues. Without forgetting Mr. Kohberger, his primary in this case right now.
Mr. Kohberger's rights are primary in this case.
All right, so let's move to, and I mean, anybody who's here for Associated Press or Gonzalez family can be excused if you'd like. We're also happy to have you stay. No problem.
Thank you, Your Honor.
Okay, thank you. Okay, thank you, Mr. Carone. All right, so what we have now between the parties is motion to compel, which we're moving out. That is kind of a on and off.
All right, so let's just pause it here. If we want to watch it, if you guys want to watch the last 3 minutes to hear them schedule the motions to compel, we can do that. I'm going to hit a few questions here. Can you quickly discuss when the grand jury trial transcripts might become public? Not knowing the law, I also wonder, are they usually publicized? No, they will probably never become public, but the defense can get them, and they've actually filed some motions that I'm planning on talking about tomorrow. So that's going to be a topic of tomorrow's live, probably around 3 p.m. Eastern time, talking about the motion to get that grand jury information. We'll look through it together tomorrow, and we will break it down. Keeley, did this judge hear grand jury evidence presented? It's a good question. I don't know how they do it in Idaho. I don't know. It could have been this judge, or it could have been a magistrate. Tori, is the gag order for the whole trial or just the pretrial? The entire process right now. Can this be revisiting once a jury is selected? Thank you, Peter, for the late night live. Peter, you know how much I love them. Yes, a lot of people requested the late night live, so I'm glad to bring the time back. But I think this gag order is going to stay in place, and the vote is agreeing with me at this point. Hopefully I didn't sway it too much. 93% say that the judge is not going to withdraw the gag order. It would stay in place the entirety of the case. Now, cameras in the courtroom, as you heard the judge say, is a separate argument. So will the media make that argument? I think they will. What will the judge decide? That's when we'll know whether or not we're going to see this trial live streamed. Right now, I'd be leaning against that as well. Ice Cold Mita. What do you think would make him remove the gag order? The evidence or what the lawyers are saying? I think the way the media is reporting it would have helped. And I think that's kind of gone. But I also think some of the arguments, if he really believes that this would violate the First Amendment and the Balancing Act more than it would violate the Sixth Amendment, then I think that could change his mind as well. Sandra, I choose forward with the gag order. I do not want this guy, if he is guilty, to have any reason to appeal, but to think like that is lawyer thinking. You're right. That's the point. We want this guy to have a fair trial for multiple reasons. Either way, guilty, not guilty, or innocent. Because if he's innocent, we need a fair trial so he doesn't go to prison for the rest of his life or get the death penalty. If he's guilty, we need him to get convicted the right way so he's not going to have an appeal and he can get the justice that he deserves and that the victims deserve, and he can get his just punishment. That's what a fair trial works regardless of what happens to Brian Kohberger. Sandra, Peter, does he have public defenders or defense attorneys representing him? Public defenders are defense attorneys. He has public defenders representing him. The public defender. Mama Pink, Peter, do you feel... Hold on, sorry. Do you feel Judge is being judgy? Well, that's what judges do, right? I don't think he's being judgy. I actually love and appreciate when a judge gives me a little wink, wink as to which way he's leaning, because even if he's leaning against me or she is leaning against me, now I know I've got to brief this. I've got until June 2nd to brief this. I got to bring different arguments. I got to bring better arguments. I got to work harder. I got to find arguments that are going to persuade this judge. Because if the judge just didn't say anything and didn't give any lean, you probably just continue on. He said, I've already briefed this judge. I briefed this issue. I briefed this issue. And the judge is saying, yeah, I read him and I read what you said about the Supreme Court. And that's not a holding, sir. I'm obligated to help you. So I love it. I love when judges tilt their hand a little bit and let you know what they're thinking, even before making the ruling. Doesn't always mean you can change it, but I like knowing. Debbie, welcome to the crew. And Zephyr, thank you. Kelly, first time chatting. What do you think the odds are for an Alford plea? I mean, I don't know. Not high. Not high. I mean, every case you could potentially have a plea like that where you don't necessarily admit it. But I wouldn't say that they were high. Tori, I believe Ann Taylor is the elected public defender, like the state attorney or the DA. She is the public defender, the top dog in the public defender's office. Keminoke, similar to the idea you threw out a while ago, is this gag order causing more harm than good regarding the Sixth Amendment? It's hard for me to tell, right? Like, is the media... So I've had some media people reach out to me and say, no, this gag order is really bad because the bad media people, the bad reporters are going in places that they shouldn't go to get sources. They're stretching on sources they know are not reliable. And it's just creating more harm than good. Shanta, why wouldn't there be cameras at trial? No kids involved. Thank you. If the court thinks that the cameras are going to create an unfair trial, then he can keep them out. If he feels like they're going to poison the jury pool or intimidate the jurors or violate the defendant's Sixth Amendment right to a fair trial, then he will remove them from the courtroom. It doesn't just have to be because of graphic nature, because there are kids involved. It can be for the protection of the process. Ashley, do you think we'll get audio of the trial? I think at the very least, we will get a similar setup to Lori Vallow. I think that trial may set some precedent in Idaho for high-profile cases where the media attention could affect what the judge thinks is a fair trial. Selah, Peter, will he be in plain clothes during trial? Will the jury know if he's being held in jail or not? He will probably be in plain clothes and either not shackled or shackled under the table. The jury will not know that he's in custody. Sue, thank you, Peter, for your hard work. Please take the family out for a Dairy Queen on me. P.S. Still proud of you. Hey, Sue, nothing makes me happier than when people say they're proud of me. I am motivated by that. I'm motivated by accomplishments and doing my best and people appreciating it. That's what I'm motivated by more than anything. And My wife got those like mini Reese cups, so I can make some Blizzard type deals at home, but they're never as good as Dairy Queen's Reese cup Blizzard. So on Sue. And by the way, Sue, I hope you don't take offense to this. I don't think it's offensive, but one of Maverick's favorite songs, he loves Michael Jackson and Johnny Cash. I know people have their feelings about Michael Jackson. I understand. I didn't like Push On. He's not my favorite guy, but he just loves that kind of music. And one of his favorite Johnny Cash songs is A Boy Named Sue. If you haven't heard it, listen to it. Carly, how often does the DA meet with Brian Kohberger? Are there limits? The DA is not going to meet with Brian Kohberger. Jesse Sue, if Murdoch could go without a gag order and live streamed, why is this any different? Murdoch did have a gag order. There was a gag order on Murdoch. A lot of that was actually sealed. There were cameras, so that might be what you mean, cameras. I think every jurisdiction is going to handle it a little bit differently. LS, why did the defendant not vocally make the plea himself? Check out our short on Twitter and Instagram. At Tragos Law is the handle. I did about 2 minutes explaining this and the different options that it could actually mean. All right. So I see enough of you wanted to watch the last 3 minutes. So let's just watch it real quick together.
Hearing disclosures of grand jury materials while protecting those materials from the public. Extension time to file.
So there are different motions. He's talking about extensions of file time to get the grand jury documents and lists to the defendant, not to the public, and then also some motions to compel.
Pre-trial motions after receiving materials from grand jury. I believe those are the motions that we have outstanding. Is this, are you arguing these or scheduling these, Ms. Taylor?
Your Honor, we can schedule all of those hearings.
Okay, when do you want to do this?
Your Honor, I think that if the court has June 26th, we can do that. We will be ready to address that round of motions on June 26th.
Excellent. We'll have that 1:30 on June 27th because the Associated Press moved that to the night.
June 27th is just my press.
Okay, perfect. We'll have 1:30. Okay. Is there anything else we need to address today, Mr. Redley? Mr. Thompson?
Your Honor, I think the June 27th should work fine. For whatever reason, our office hasn't seen copies of the grand jury trial motions, but I think there was a miscommunication. Those will be prepared.
Okay, great.
I believe they have been made public now, and I've seen them. So again, we're going to talk about the grand jury stuff tomorrow.
And certainly if
Michelle,
those,
they're the best.
issues are resolved between counsel, then we will have to have a hearing.
Yes, sir. Thank you.
Okay, so
As with
anything else
anything.
we need to address today, Ms. Taylor?
No, Your Honor, thank you.
Okay, thank you, Mr. Watson. Okay,
So that's it. And again, if the lawyers can come to an agreement, then we don't have to ask the judge. Thank you, Tori. Brooklyn basement, standing silent, less relevant than it seems. Probably means nothing, but they had to make the decision to do that. And again, there could be a reason. And if there is a reason, I did a video breaking down all the potential reasons I could think of. Nicole Mobley, when will we find out about the death penalty? So they have 60 days. The state has 60 days from today, the day of the arraignment, to file their notice of intent to seek the death penalty. So sometime within the next 2 months, we will find it out. Liz G, your wife picks out great pillows. Maybe we can add some lawyer you know ones in the mix. Now that's a good idea. I like that. I don't know if she would like that, but I like that. Carly, how often do the public defenders meet with? Oh, okay. I should have picked that up, Carly. Usually, because listen, I have typos all the time too. So usually I can pick up and figure out what people mean, but I didn't think about it long enough. So that's my B. There's no real limits. They can meet with them every day. They can meet with them for a lot of hours. Some jails have limits on visitation, but usually the lawyers are not held to those limits. Obviously you can't do it all hours of the night, but as often and as long as they need to prepare him to be effective counsel. Run the World. Came across your channel a few days ago and joined right away. It's fantastic. Thanks. Thank you, Run the World. I always like to hear for new people that come and join in the channel and subscribe, become a member like you did. Which case brought you in? Was it this Brian Kohberger case? Was it one of the recent cases we covered? I just like hearing what cases bring people in. And if they stick, I love it. I love it because I love every different perspective makes this more enjoyable, more educational, and just a better feel for being a finger on the pulse of potential jurors. That's what I really love about it. So thank you for joining us. Amber, Banfield does more harm than good. Sonia P. Peter, can they modify the no gag order? The non-dissemination order? Yes, they can modify it. The judge can do whatever he wants. He can completely write a different one if he wants to. Or he can just adopt it, or he can amend it, or he can throw it out. The judge has control because it is his case now. So he gets to decide what's going to happen with the non-dissemination order. It's going to be up to him. M. Jackson, what is the chance of him being found guilty on 2 of the murders, but not the other 2, since some feel he was not alone? I really, really, really would be surprised if he was only found guilty on some of the murders and not others. I really would. I think it's going to be across the board, either guilty or not guilty. So I would say the chances are slim to none, would be my guess. iSchool, thank you for the super sticker. Vicky, okay, now who's going to bring me some ice cream? Yeah, seriously. Her Brave Lily, this was the favorite piece of merch that I wanted to buy. I love these 5-panel hats. And I love the this clip on the back too. Is just kind of cool. It reminds me of beach volleyball. I don't know why. Like the Top Gun scene, where they're playing beach volleyball. I don't even think anybody's wearing a hat like this, but I do like it. Oh, that's cool. Michelle, I normally have the cherry gelato from Rita's Water Ice during the summer. So we have Rita's Italian Ice. I don't know if that's the same thing. I used to love it. I used to get it every day after football practice when I was in high school. But then I didn't really like the mix. Now if I do get it, I don't get any of the custard in it. I just get the ices. Yep, a lot of people gifting memberships again. They always do. This is the type of channel and community it is. They gift more memberships than I can ever even say thank you for. A lot of people saying Grizzly, Emily D. Baker, Daryl Brooks case, Amber Heard case. No Dairy Queen for me, just Rita's. All right. So listen, we got it all done. Got all the questions answered. Video watched, everything within an hour, which is just how we like it. So thank you guys so much for joining me for the 2 Live crew today. And again, tomorrow we're going to be talking about these grand jury documents. Thursday, you have until Thursday to join the membership crew because that member's only live. I think it's going to be fun, but I can't wait to hear what you guys think about it. I appreciate you always. Hit that like button on the way out and subscribe to our channel if you haven't already, so you can join in future videos. We will go out with John here. They wouldn't withhold all the discovery permanently, right? Just making sure. So they're only going to withhold things that they don't think they need to turn over. So if they don't think something's discoverable, they will withhold it forever, but then it's not really discovery, right? If the judge holds that it's not discoverable. Anything the judge says they have to turn over, then they are going to turn over. Eventually. iSchool is a member. Debbie W. Rick Rossovich had 1 in the original Top Gun. All right, there we go. All right, I'm out of here. I appreciate you all. Last one, Brooklyn. This is the last one. Brooklyn Basement will think the leaks will be held accountable unless there's a very obvious connection. I think the judge is just going to give general reprimands and general warnings like he kind of did today. That's what I said a few days ago. That's what I expect, is him to say the media is already affecting the fair trial. You better stop. That's what I expect more than any direct accountability, unless they can prove it, which we'll see if they can. All right. Appreciate y'all. I'm out of here. Now, I am a real lawyer. May surprise you, but if you want to hear about a little bit more about what I do, stick around for the outro. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.